The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. Our first case this morning is Copeland versus Amward Homes of NC Inc. et al. And we will hear from the appellant.
Good morning, Mr. Chief Justice, and may it please the court. My name is Stephen Bader, and I represent the defendant developers in this case. I'd like to reserve 5 minutes of time for rebuttal. The issue is whether a developer can delegate responsibility for construction site safety to an independent contractor. In a larger sense, the question here is whether landowners in North Carolina are protected by the traditional boundaries of tort law, or whether those boundaries can be redrawn by expert testimony. Court of Appeals held that the developers in this case may have a duty to mass grade the development or sequence construction to protect against the risk of a rollaway accident. That duty comes from the testimony of plaintiff's experts. And in rendering its opinion, the Court of Appeals conflated the issue of duty of care, which is a legal question for the court, and standard of care, which can be informed by expert testimony, but only if a duty exists in the first place. Now, this case stems from unimaginable tragedy, and we acknowledge and recognize the heartbreak at the center of this case. And as upsetting as this accident is, North Carolina law is well established. Responsibility for construction site safety can be delegated. The rule announced by the Court of Appeals abrogates this principle and imposes duties on developers in North Carolina that are unprecedented. And in fact, the plaintiff has cited no case law from this state or any other state where a developer was tasked with the duty to guard against the risk of a construction site accident.
Mr. Bader, I hate to interrupt you so early in your presentation, but I did not read the Court of Appeals opinion as creating a delegated duty. My understanding is that they held that the developer had put on experts that forecast that the developer knew of hazards and risks associated with rollaway equipment on hilly construction, such that they had the duty of a reasonable developer themselves. Can you point me to anywhere in the Court of Appeals opinion where they say that they're talking about a delegated duty?
Well, Justice Hudson, what those expert opinions were stating was that a developer, such as these developers, should have anticipated this risk, not that there was particular facts that would indicate that these developers did in fact anticipate this risk. And what the record has demonstrated is that these developers do not have knowledge, experience, or skill in home construction or home building. And so they delegated the responsibilities for risks that are incident to home building to the builders that bought the lots and performed the construction.
Right, but that's not what I'm talking about, and I don't think that's what the Court of Appeals was talking about. I'm talking about the risks associated with grading on a steep lot, and whether their experts testified that there were risks that and hazards that the developer themselves knew or should have known about if they were acting as a reasonable developer in this situation. Well, can you point me to somewhere in the Court of Appeals opinion that says otherwise with respect to that third issue?
Well, Justice Hudson, I'm not entirely sure I'm tracking with you as to what you're asking me to point to, but what I think I can say is that these experts were offering opinions as to what they believe a reasonable developer should have done with respect to anticipating risks associated with grading. But whether a legal duty exists and whether that duty to perform ordinary construction can be delegated is a question for the court. An expert does not get to state whether or not a duty should be imposed under a certain fact pattern. I think when the court looks at what this duty to mass grading comes down to and how it's defined, the opinion of these experts is that the developers who hired Fred Smith to do the mass grading work should have had Fred Smith do more grading work, because if they did, then the developers, or I'm sorry, then the builders would not have done this work on their own through their subcontractors and done the work negligently. And I think it's important to pause here and clarify those facts. The developers hired Fred Smith to perform certain mass grading at this development. The builders, under their purchase agreements, had responsibility for performing other grading on the site. And at the time that this accident occurred, the grading work that was going on was the work that was within the scope of the builder's responsibilities. And we have testimony on that point from Mike Ward of Amward Homes, who was asked about that. And he testified the work that was going on was not within the scope of Fred Smith's work.
One thing that
That sounds like a factual issue to me. Is that not a factual issue?
Well, Justice Hudson, it's not, because the only dispositive testimony on that point is from Amward Homes, and they said that this particular grading work was within our scope of work, and there's no other evidence to suggest otherwise. But to the extent that the court thinks that there is, or finds some, we would also add that as a matter of law, an assumed duty to undertake a certain task, so in this case, an assumed duty to hire Fred Smith to perform certain grading work, does not extend to a duty to prevent builders that we have no right to control from doing that work themselves and doing it negligently.
Well, counsel, while you say that it's not up to the experts to establish what the court is to establish, the Court of Appeals did say that as far as what was put forward by the experts and by the plaintiff's evidence in general, that there had been posited at least enough evidence by the plaintiffs to survive a summary judgment motion. And of course, it is in the plaintiff's brief that summary judgment is disfavored, which of course is an established rule. Why should not, at the very least, the evidence put forward by the plaintiffs through the experts survive summary judgment, a dispositive motion?
Because, well, the experts, again, can inform the standard of care. They do not put forth evidence on whether, in fact, there is a duty of care. So, for example, using this exact same fact pattern, you could have another builder on site that was working across the street from where this accident happened. And that builder could have seen the dump truck operator, even suspected that what that person was doing may lead to an accident. The accident could happen and the builder could be sued. And presumably they would defend that case saying, we have no duty to guard against contractors that we don't hire, working on land that we don't own, over which we have no responsibility. And the plaintiff could find an expert to say that a reasonable contractor in that circumstance should have done something. That in that expert's opinion, the industry standard would be that that contractor should have taken some steps. But that question doesn't go to a jury. It's a question of law. And in this state, responsibility for construction site safety can be delegated to independent contractors. And that, paired to its essence, that is what this case is about. It's a construction site accident, and the theories posited by the plaintiff's experts are that these developers, before construction began, should have taken some precautionary steps to guard against the risk of a construction site accident. And
well, aren't the lines somewhat blurred as to where you say the duty ends for a developer and where the reasonableness standard for what a developer decides will be done begins, leaving that to a trial judge to determine? And once the trial judge determines that, then the reasonableness standard comes into play, and then the jury comes in and serves its role.
I don't think that's the case, because a developer is no different than any other landowner in North Carolina, and the landowner will certainly having duties within that sphere of the common law has the ability to delegate responsibility for safe construction practices to a contractor. And there is no case law that says before that delegation is made, there can be some inquiry by a judge or a jury as to whether or not the delegation was reasonable. Once it's delegated, those duties which are incident to the risk of the contractor's work are outside of the responsibility of the landowner or the seller.
Mr. Bader, you would agree, wouldn't you, that the general rule in tort law is that the developer has a duty to behave as a reasonable developer under the circumstances?
Well, Justice Hudson, I agree that all landowners are tasked with that duty as a matter of law, but that doesn't override the principle that when contractors are hired to do work, that those duties can be delegated.
I'm not talking about that. I'm talking about the duty the developer has as to act as a reasonable developer. You're not disputing that the developer has a duty under general tort law to act as a reasonable developer would, are you?
I am not disputing that. That same duty attaches to every landowner. But once again, when it comes to construction site practices that are incident to the work of a contractor, those can be delegated under North Carolina law. When we look at the duty to sequence, really what that duty states, and that's the second opinion of the plaintiff's experts, is that the developer should have required all of the homes on the highest point in this particular phase of the development, that those lots be sold and that those lots be built out before any homes are built lower. Now, as a matter of common law, there is no case law that supports the idea that the seller of land would need to refrain from selling their land in some particular sequence or because of elevation changes, or that a seller of land would have any obligation to put conditions on how that land is built up after it's sold. But with the duty to sequencing, and this is also true of the duty to mass grading, that doesn't prevent this particular accident. Hypothetically, all of the higher homes could be built out first. But during that construction, a dump truck could roll away and could harm another worker on site, could harm another pedestrian that happens to be walking by the neighborhood. For that matter, all those homes could be built up, construction could be starting at a lower phase, and a dump truck could be driving up the hill and using that road for any purpose, and this accident could still have happened. Sequencing doesn't prevent the accident. Safe operation of a dump truck is what prevents the accident. And this is operation by a contractor that the developers did not hire, working on property that the developers did not own, when the developers did not know the work was being done. And to kind of close the loop on the duty to sequence, it is an unreasonable restraint on property to say to an owner of land, you cannot sell your land that happens to be situated lower than other lots until every single one of those lots is sold and built out. If the seller is hiring a contractor, or in this case, selling to a contractor to perform construction work, the seller can rely on that contractor or task the contractor with that duty to perform that work in a safe and reasonable manner. And this could be extended out in many other circumstances. You could have an instance where an individual happens to own land that is above properties that have already been developed. Under the Court of Appeals opinion, that same owner of land may be tasked with some duty to try to anticipate the risk of a construction accident if the decision is made to sell that land to a contractor with the appropriate knowledge, experience, and skill to undertake that building. I've said a couple times that responsibility can be delegated for construction site safety, and there's of course one notable exception to that, and that is if the work to be performed is inherently dangerous or ultra hazardous. And there's this court provides a very nice discussion of that concept and that principle in the Woodson opinion. And really the duties set out or recognized by the Court of Appeals and advocated by the plaintiff in this case are really an end around for what Woodson recognizes. Because under Woodson, a developer can hire a contractor to perform inherently dangerous work on the property. And that developer has a non-delegable duty with respect to that inherently dangerous work. But under Woodson, and what was true of the developer in that case, when the developer puts forth evidence that they have no knowledge, experience, or skill with that particular construction task, then summary judgment is appropriate. Now, I'll grant this court.
Well, the issue in Woodson was very different from the issue here, wasn't it? It was whether there was an exception to the workers' comp exclusive remedy because of the employer's essentially intentional act in placing the worker at risk. That's not what we have here, is it?
Well, Justice Hudson, you're correct. That is primarily what we know the Woodson opinion for. But Woodson also provides a discussion about when contractors can delegate responsibility for construction tasks, construction safety, and recognizes an exception when construction is inherently dangerous.
Well, I'm not reading the Court of Appeals opinion here as holding that this was an ultra hazardous activity or anything like Woodson did.
And that's correct, and it's not. And my comment on that really goes to that the policy that this court seemed to recognize with that rule in Woodson is that if a developer is going to undertake inherently dangerous work on their property, the duty is non-delegable. But the developer can effectively discharge that duty and have no liability on summary judgment as a matter of breach if the undisputed record shows no knowledge, experience, and skill in that task, which is precisely what this record holds. But under the Court of Appeals opinion, a developer can delegate responsibility for ordinary construction, which is not inherently dangerous, dump truck operation, which is not inherently dangerous under this court's precedent, and a duty can still linger to take some precautionary action before construction commences in anticipation of a rollaway accident.
As I read the Court of Appeals opinion, it is that the developer keeps the duty to behave as a reasonable developer, given their knowledge of the risks associated with what they're doing, like any other developer in that situation. Or as you said, like another landowner, that they maintain the duty to act as a reasonable developer.
Well, and
isn't that what the Court of Appeals says?
I'm not certain I necessarily agree with that particular characterization of it. I don't disagree, and let me answer that question in a better way. I don't necessarily agree that that's the Court of Appeals characterization. But my argument in response to that is that we don't foist a reasonableness standard on a landowner that has delegated responsibility for construction site tasks to an independent contractor. That is what the case law recognizes. And so to say that there is a standard on a developer that would be any different than any other landowner is unprecedented in this court's precedents or in the Court of Appeals precedents or any other court from any other state that I'm aware of.
But what would also be unprecedented, as I read the plaintiff's argument, is to hold that the developer has no duty to act reasonably at all.
I don't think that's a fair characterization of our argument. I mean, our argument is that what the developer in this case did is recognize its own limitations. And to be clear, to the extent that this is murky in the record, the developer doesn't self-perform any work. It does not self-perform anything. Everything that's done is tasked out to contractors or vendors with the appropriate level of knowledge, experience, and skill. And that's contrasted from the Trillium Ridge case, which I know is cited in the petition for discretionary review, if not the briefs, where you had a developer that for its own reasons, played a more active role in overseeing the construction process. But here what you have is a developer that recognizes its own limitations, what it cannot do, and tasks those responsibilities out to independent contractors.
Can I just ask you about that? Because as I understand the facts as taken in the light most favorable to the non-moving party, they are saying that the developer did take on certain, certainly some decisions about how the development should occur. So decisions about when the lots would be developed, who would build on which lots, and even how the builder should start by building a gravel driveway, and the decision about when to start building, that all those things were in the control of the review board that was the developer's staff. And that what the plaintiffs are saying is that it was those actions by the developer that were not, that created a duty to act reasonably and were not followed here.
Justice Earls, to your first point, your first comment, the only real, and I think this goes to the sequencing, the only thing that developers did in that respect was decide which phases were going to be built out first. And that's really this whole idea that you have to phase it so that higher land is built before lower land. Beyond that, the builders sold lots as market conditions dictated and built as buyers requested. But to the issue of the covenants give the developer the right to enforce aesthetic and architectural controls in this particular development. It's not uncommon to what if not all homeowners associations in the state have. And within those covenants, there is no obligation on the developer, no duty undertaken to inspect or to monitor the construction site. And the Court of Appeals opinion made a specific holding to that effect. That's not a duty that was undertaken. And so then we go to the common law, and the common law does not impose a duty on somebody who sells property to otherwise inspect or maintain the property. So when the plaintiff's expert says that the industry standard would be for inspections to occur every couple of days to determine whether or not unpermitted work is going on, that doesn't create a fact question on the duty of care when the developer has not assumed that duty and the common law doesn't impose it. But building on that, the facts do show that the developer did have an individual that would drive the property and take a look at horizontal building and other things of that nature. His testimony was unequivocal. He is not a construction expert. He is not in a position to judge or look at how construction is done. All he can do is look at aesthetic and architectural features. There was no testimony that we had any knowledge of any work being done on Lot 112. And presumably the reason for that is because at no point did the builder submit plans for approval that would have caused the review board to send somebody out to look at whether or not the architectural features are complied with. And as I was working through this argument the last several weeks, I think an analogy, at least that's helpful in my mind, is to look at a homeowners association. Because the homeowners association is really the offspring of the developer declarant. That's the entity that's tasked with implementation and enforcement, if you will, of the covenants after the development is done. And homeowners associations under their covenants may require a member to get approval before work is done, before they do roofing work, siding work, tree work, various works of that nature. Now, if a member of the homeowners association doesn't seek that approval, they hire a contractor who performs the work, and the work is performed negligently, we would not bring in an expert witness to say that what a homeowners association should do, because it is reserving rights pursuant to their covenants, is to have somebody monitor the property or the neighborhood for unpermitted construction work and do something to stop it. Because the homeowners association doesn't own the property, they didn't hire the contractor, they don't have any legal responsibility for what the contractor is undertaking, and there is no otherwise common law or statutory obligation on the homeowners association to be responsible for that work. And that is really the parallel of the arguments against this defendant. And I would conclude my remarks with this. This is undeniably a very upsetting accident. Nobody's going to dispute that. But North Carolina law is well established. Responsibility for construction site safety can be delegated, and the Court of Appeals opinion at best abrogates this principle. With that, I'd reserve the remainder of my time. Thank you.
Thank you, counsel. We'll hear from the FLE.
Chief Justice Newby and fellow justices of the North Carolina Supreme Court, I'm David Kirby, and I represent Everett Copeland. I'd like to reserve 5 minutes of my time for rebuttal. I think it's well settled law in the state of North Carolina that any person who undertakes an active course of conduct is under a positive duty to exercise ordinary care to protect others from harm. A violation of that duty is considered negligence. That is the Council v. Dickerson case, the Fireman's Mutual v. High Point Sprinkler case. And here, Crescent, the developer, undertook to develop the subdivision Forest Ridge. Unlike other folks, they have the same duty imposed on them that the courts impose on everyone, to exercise ordinary care in the tasks that they undertake. Now, specifically here, the tasks that the developer undertook were 3 things that are very important. 1, the developer undertook mass grading. The developer undertook the sequencing of lots. And thirdly, the developer undertook and controlled the commencement of construction. Not supervision or monitoring of construction, but they controlled commencement of construction, and they had certain predicates or conditions before construction was to begin, and they also retained the power under covenants and under the homeowners association and under the architectural control committee, which they controlled the homeowners association, the architectural control committee. They retained the power to remove any contractor or subcontractor who violated the rules, starting with mass grading. When this project began, Crescent obtained a permit to mass grade the entire subdivision. For whatever reason, they did not mass grade the ridge lots. As a result of that, those lots were so steep, they were really unbuildable, and there were other lots nearby where you could not build on those either because of the lack of soil. Concave lots.
Mr. Kirby, I'm sorry to interrupt you, but I wanted to ask you for clarification about, you said that the developer undertook 3 tasks.
Yes.
And for themselves. And my question is, how did they undertake that? Is there a written place where they say they do that? Is there a contract?
Well, Justice Hudson, first of all, they obtained the permit to grade the entire property, all the property, which would include phase 1 where this tragic accident occurred. That's 1. Number 2, when they entered into their purchase and sale agreements with the builders, in that particular document, they indicate that they are responsible for mass grading and the builder is responsible for what's called fine grading. I think a really dispositive event occurred in August of 2015, and I would direct the court to document exhibit 555. In August of 2015, this was about 2 years after this development had begun, there was an email exchange between Joe Walker, who was the director of development at Crescent, and Michael Ward, who was the president of Amward. He was later on the person who owned lot 111 at the time this tragedy occurred. But in the email exchange it was initiated by Crescent, and the discussion was trying to get fill dirt to fill in lots which were unbuildable. And the discussion was that they were going to take dirt from the ridge lots. That's where this tragedy occurred. They were going to take dirt from the ridge lots and use it to create fill dirt so that you would have a buildable ridge lot and you would have a buildable lot that was on the lower part of the ridge, but still on the ridge. During the course of that exchange, it was asked, well, could Gary, which is Kayla Contracting, could he do this work. It was responded by Mr. Ward that he is not set up to do this work. Discussion continued that they would use Fred Smith. The most important comment that is made in that exchange is the following. Mr. Walker says to Amward, I by no means am I trying to shirk our financial responsibility. Why is that important? Because Crescent is acknowledging, this is Crescent management, acknowledging.
Now Walker is with Crescent,
Walker is with Crescent. He's the director of development of Crescent.
and Mr. Ward is with,
Mr. Ward is with Amward Construction, who at the time of this tragedy owned lot 112.
okay,
And
Thank you.
it was their subcontractor, Gary Ward and Kayla, who were on the property and operating the dump truck on the day of the tragedy. But this is about a year prior to that. There's this discussion, and Crescent acknowledges it is their financial responsibility. What is the reasonable inference from that? The reasonable inference from that is if it is Crescent's financial responsibility to do this mass grading across the ridge lots, then it is also their task responsibility. It's their task responsibility. It is their financial responsibility. It is the responsibility of Crescent. Crescent would not be paying for this. If this was, quote, fine grading, Crescent wouldn't be paying for this. It would be the financial responsibility, task responsibility of the builder, but it was not. So this is an obligation that Crescent agreed to undertake. They acknowledged it was their responsibility to undertake. And sadly, they didn't mass grade initially when they got their initial grading permit. They didn't mass grade after they made their agreement with builders that they would take care of mass grading. And sadly, here just slightly over a year before this occurred, they agreed to do it.
So Mr. Kirby, are there any documents or other forecast evidence in the record indicating that Crescent delegated that responsibility for mass grading at some point down the line?
I don't see any documents where they delegated that responsibility to anyone else, Justice Hudson. It was their responsibility. As a matter of fact, the conclusion of that email exchange was the director of development telling Mr. Ward, Amward, that they had a grader coming out on Monday to estimate the job. And he was given information about this is the kind of permit you need to get from Orange County to do land disturbance. So again, a jury can infer from all this, it is their responsibility. They voluntarily undertook it. They contractually obligated themselves to do it, and they failed to do so. And what is important and very critical, Justice Hudson, is that the testimony from Steve Farlow, the accident reconstructionist, is that at the time of this truck's dislodging and rolling down the hill, the brake, that is the parking brake, was actually engaged on this truck. And had that slope been just 2% or 3% lower than it was, this brake was sufficiently strong to keep the truck on the lot. So the truck would not have gone off the lot had the mass grading been performed as Crescent said it would. That factor alone should be sufficient to take this case to a jury for determination.
Let me ask you this. It seems
Sure.
like that your colleague argued that theoretically, Crescent could delegate the mass grading responsibility. What is your position? Not necessarily looking at the record, but just theoretically, can a landowner, developer, delegate grading to a third party?
Justice Newby, absolutely. I mean, part of what's going on here is that my colleague, Mr. Bader, who's incredibly bright and argued incredibly persuasively, is trying to paint this with a very, very broad brush that somehow this is going to impose all kinds of additional obligations on developers who try to go out and develop a piece of property. And nothing could be further from the truth. What this case is about, just like every negligence case, it's about what are the specific circumstances in this case? What are the specific facts in this case? And can a developer hire someone to do work? Sure, they can hire someone to do work. But a developer has the same obligation that a carpenter does, a lawyer does, a doctor does, a truck driver does. They have an obligation, if they undertake an active course of conduct, that they're supposed to act with reasonable care to protect others from harm. And that's we're not imposing any greater obligation on developers as we are anyone else. If you take the argument of Mr. Bader to its logical conclusion, what he's saying is that this obligation does not apply to developers. And I don't think that's the law of this state. I don't think that's where the court wants to go. If developers want to have no responsibilities in how they develop, how they sequence construction, what tasks they undertake, they can go to the legislature and they can seek to obtain immunity. But no immunity has been granted by our legislature, and I don't think any type of immunity should be carved out in this case. So I think in the first instance, Justice Newby, this is a situation where Crescent, the developer, these are not court-imposed responsibilities that came from the Court of Appeals. These are self-determinations, self-decisions that were made by Crescent in the manner in which they wanted to develop. The second thing that Crescent did, when they failed to mass grade, now you have a situation where you're going to have to bring in heavy earth-moving equipment, excavators, dump trucks, and the like, and you're on a ridge. And what they did was, in the sequencing of construction, this is not a situation where they put on a board, here's a group of lots, builders come in, choose, build wherever you want to build. The very opposite occurred. They took a look at their property. They chose, that is, Crescent chose what lots they wanted to build on, when those lots were going to be built on, where people were going to be residing in that community first. They made those decisions, and they made a decision to put everyone down at the bottom of the hill and had no construction on the ridge line, so that they create a situation where you have a number of children and families living at the bottom of a very steep hill when construction activity has to take place at the top of the hill. And in other words, you're putting the residents of this community into the path of danger and to the path of harm.
With regard to those decisions that were made, the Court of Appeals does say in its opinion that while established tort principles do not weigh in favor of your client, that nonetheless foreseeability was established in a way that should survive summary judgment. Do you feel as though the Court of Appeals is correct in talking about foreseeability? And to the extent that foreseeability should be a consideration for this court, how should we consider it?
Well, I think foreseeability, Justice Morgan, is our courts have always held that foreseeability is essentially it's a question of fact for the jury. And so, because the test is what could a reasonable person foresee? And specifically in this event, you don't have to foresee the exact or precise event that occurred. You don't have to foresee that a dump truck is overloaded and the driver departs the dump truck and it rolls down the hill. The test, and I think we have met the test that is imposed under the law is whether a reasonable person can foresee that some harm will result from their conduct or consequences of a generally injurious nature. That's sort of the black letter law definition of foreseeability, which is a component of proximate cause. And that's the Hairston v. Alexander Tank case.
What would be your response to opposing counsel's position, as at least I heard it, that foreseeability would not even be an issue here for the developer, because if the developer has delegated all of this to the contractor, then there is no need for the developer to have to expend foreseeability because it's all been delegated to the contractor.
Well, two things about that, Justice. They undertook the responsibility of mass grading. And when I say that, can they hire a contractor to actually perform it? Yes. But in the planning of this development and in the sequencing of this development, they have to plan it and sequence it in a way that they don't create harm for others. They have to act with ordinary care. And the testimony here is that, these types of rollaway accidents are foreseeable. The notion, I mean, some of this is just gravity that we learned as small children, but the idea is that could a reasonable person foresee that having active construction activity where you are placing residents, that they're the ones that created this situation where they're putting residents in the path of active construction. That was their decision, the developer's decision. That was not an individual builder's decision. That was the developer's decision to do that. And so I look at this as who created the dangerous conditions that were the precedent of what occurred. And again, I'll go back to the Hairston v. Tank Lines case, Justice Morgan. If you look at the case, it's a situation where a gentleman bought a new vehicle and he changed the tires out, and the dealer did. And when they did, they didn't put the lug nuts on the tire. And obviously his vehicle broke down a few miles after he left. And then a vehicle comes up and strikes him when he's changing the tire, and a fatality occurs. And so the court ruled in that case that, that the wrongful conduct of another may be, what creates the second event that occurs. And so again, in that court's view, this was a question of foreseeability, which is left to the jury. Is an issue of proximate cause, which is left to the jury. It's questions of reasonableness, which are left for jury determination. And I see this as a classic example of it's the direct negligence of the developer that joined with and concurred with the negligence of the dump truck operator or the landscape contractor. This is joint and several liability situation. It's concurring negligence situation. It's multiple proximate causes. And under the law, a plaintiff who comes to court is required to prove, was the defendant, in this case it would be Crescent, was the defendant negligent in one or more ways? That is the burden on the plaintiff. And was that negligence a proximate cause, one of the causes of what occurred? We have testimony from, again, accident reconstructionists. There's no question that the failures of Crescent was a cause of what happened. There's also expert testimony from Mr. Brewer as well, that Crescent's failure. So there was negligence in failing to fulfill their obligations to mass grade. There was negligence in failing to fulfill a reasonable care in how they sequenced property. And lastly, Crescent they retained to themselves, because they controlled the board, that is the homeowners board. They controlled the architectural control committee, and none of that control was released until 80% of all the lots were sold. Well, you probably had 10% of the lots sold at this point in time. So Crescent is controlling the homeowners association. They're controlling the architectural control committee, and those rules and regulations were part of the covenants that went with the land. Everybody bought a piece of property, had this covenant, and Crescent retained to themselves the power to enforce those rules. Included in that power was the power to Crescent that they could remove a contractor. They could remove a subcontractor from the property who violated those rules. And in this particular situation, where that's important is that no construction was to commence until there was a temporary driveway put in, a silt fence was placed, and you had to get plan approval. There was no plan approval. There was no temporary driveway. There was no silt fence. Kayla had been out there for 10 days conducting work. The vice president of Crescent has testified under oath that Crescent had a responsibility to inspect the property a minimum of once weekly, and if there's any activity taking place, to inspect it more often. Our expert says, well, that's consistent with the standard of practice for developers to inspect. But Crescent acknowledges that duty to inspect. The second thing I would argue to this court is if you undertake the responsibility to enforce construction rules, or you undertake the responsibility to enforce the covenants, there is an obligation inherent in that responsibility that you have to conduct some kind of reasonable inspections at some point. If it's your duty to enforce, to make sure that construction's not taking place unless approved, et cetera, then you have some type of obligation to inspect. And here this took place for 10 days. It was obvious Crescent should have gone out, Crescent should have stopped. Again, testimony is, had that driveway been there, the construction rules require that all construction vehicles have to use that dedicated driveway. Had it been used, same situation with the accident reconstructionist, this vehicle would not have rolled off the lot, and this horrible tragedy would not have occurred. So,
Mr. Kirby, you referred to construction rules.
yes.
Are they, where are those found in the record?
Okay, the construction rules are part, just let me see if I can find that real quickly. I think it's the Master Declaration of Covenants or Document Exhibit 99, and the architectural rules are found in Document Exhibit 111. And essentially those rules, Justice Hudson, they're architectural guidelines, they are landscape guidelines, and they're construction rules. And the particular rules, if you look under the architectural guidelines, it's the timing where it says that you have to have prior approval before commencement of construction. If you look into the construction rules, I think it's maybe 6 or 7, somewhere in there, where you have the obligations dealing with a dedicated driveway, the use of the dedicated driveway by construction vehicles, and that, again, no construction is to commence until that driveway is in place. So I go back to where I started. This is a negligence case. Negligence cases are by their nature circumstance cases. What are the circumstances? And they're always fact specific. To the extent that there's a debate about whether this is this mass grading or is this fine grading, that's a question for the jury. Whether this was foreseeable, not foreseeable, that is a question for the jury. Plaintiff feels that he has produced sufficient evidence from which a jury could find that Crescent, the developer, undertook duties, 3 specific duties, as a matter of fact. They failed to meet their obligation in fulfilling those duties. They breached those duties. As a result of that breach, it was one of the causes of this terrible tragedy. And this is, again, a situation where an independent act of one party sadly combined with an independent act of another party and produced this horrible and terrible result. There is, discussion here about also no duty to anticipate negligence of others. I know that's been in the brief. I just want to indicate if we look at the Chafin Brame, the Bean Blossom case, the Harrison Alexander Tank case, all of those cases indicate that foreseeability is a question of fact for the jury. They indicate you do not have to foresee the precise act in the way that it occurred. You have to only foresee that some injury or consequences of a similar injurious result would occur. And lastly, I think Alexander Tank is very important because in that case, it indicates that the intervention of wrongful conduct of others may be the very risk that the defendant's conduct creates, and notes that occasional negligence is one of the incidents of human life. So,
And let me make sure I'm understanding. The Court of Appeals specifically says that those issues like intervening or superseding causation and other types of issues that could be defenses are still on the table in the trial court.
correct. Those are issues for the jury, Justice Hudson, because
Okay.
this is a negligence case.
Okay, so you're not disputing that those issues could still come up later.
They could come up later. I don't think that I don't think they're appropriate under the facts of the case, but they can be argued by the defendant, and they can at least put evidence and make that argument. But again,
But they're not before us at this point.
not before this court, because again, this is a question of, have the case is at the posture of summary judgment. If we take all the evidence in the light most favorable to the plaintiff, accepting plaintiff's evidence as true, giving it all the reasonable inferences that are there, has the plaintiff produced sufficient evidence to show that Crescent had a duty, that it breached a duty, and that it caused harm? We all know that harm was caused here. A horrible tragedy occurred. And I think there's abundant evidence to show that Crescent undertook these duties voluntarily. They took them on themselves. The court didn't impose these duties on them, and that they failed to fulfill their obligations, and that sadly their failure was combined with negligence of another party and caused this very sad death of Everett Copeland. So I would ask, I'm going to stop at this point, reserve my remaining time, but I would ask the court to remand this case to the Orange County Superior Court for trial on the issues so that Everett Copeland gets to have his day in court. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Mr. Chief Justice. Very briefly, mass grading and delegation. I want to make sure I'm clear on this point. The developers did not do any mass grading. All this was delegated to one contractor or another. The argument, the mass grading was delegated to Fred Smith. Other grading was delegated to the builders. Now, again, we would maintain that what the record shows is when this accident happened, the grading being done was within the builder's scope. But either way, there is no legal principle that says the duty to have one contractor, to delegate a task to one contractor, extends to a duty to stop another contractor from performing that task. And that is really what the grading argument boils down to, because this is not a grading accident. This accident didn't happen because Fred Smith didn't grade. It happened because the dump truck driver was negligent in the operation of his vehicle. The second point that I want to make gets to Justice Morgan's questions about foreseeability. And what Cook versus Morrison, building on Woodson, recognizes is that there are an innumerable number of risks at a construction site. You've got falling beams. You have other pieces of falling equipment, nails, sharp objects, rollaway vehicles. And while all of those risks are different, and they may all in fact be foreseeable with the benefit of hindsight, what the case law says is if you as the landowner delegate responsibility for construction to an independent contractor, you have no duty to guard against any risks incident to that work. And the reason, and it's expounded upon in the McCorkle decision, is because when a landowner cedes or relinquishes, I think is the term they use, relinquishes possession and control of property to a contractor with superior knowledge, expertise, and skill, there's no duty for that landowner to then oversee, anticipate negligence, or the like, the contractor that has that superior knowledge, experience, and skill.
It seems like your colleague has agreed that the developer does have the right to delegate. I think what the argument is that under the facts of this case, that delegation was never done. Can you show us in the record why that why that delegation was done?
Well, I think, Chief Justice Newby, that the record is pretty clear that the developer didn't self-perform any work. Everything was delegated to somebody, be it Fred Smith or be it the builders. And if I'm understanding your question, and please correct me if I'm not, my response as a legal matter would be, if the developers delegated the grading to Fred Smith, which they did, and Fred Smith didn't do it, that as a matter of common law, the duty on the developer would not extend to stopping the builder from performing the work that Fred Smith should have done negligently, which is really a principle of legal control. And I cited to this court the Stein and Bridges decisions, two relatively recent opinions of this court that we concede in our brief and will certainly acknowledge here again this morning are factually and legally distinct. When you look at the Bridges case, just as an example, that's the case where the adult parents had a firearm in their home, did not prevent their adult son from accessing the firearm. Ultimately, he obtained it and committed some horrible act. And there was argument or suggestion in that case, similar to what we're hearing here, certainly distinct, that it was the parents' home, it was their firearm, and they could have done something to prevent the accident. And what this court recognized is they don't have any legal right to control their adult son. And so the notion of refraining from setting the stage for somebody else to commit a tort is not where duty extends. I see my time is running short. Unless this panel has any other questions, we would ask that the opinion of the Court of Appeals be reversed.
Thank you, counsel. Rebuttal with regard to other issues, Mr. Kirby?
No, just very briefly, Judge, just back to that point of what was addressed. Crescent itself knew that the ridge line needed to be graded, and it had a duty to make sure that it was. I mean, it was their responsibility, and it was never performed. That was their responsibility to see that it was performed. They could hire someone to do it, but they failed to perform their task, and that was one of the causes of what occurred. And then lastly, as he's talking about the notice concept, there is information in your record there where about 2 months before this tragic accident occurred, a dump truck, which was moving dirt, that is hauling dirt, overturned. And there was also complaints from homeowners about both speeding in the subdivision and construction trucks blocking traffic. So the Crescent was knowledgeable and on notice that there were dangers associated with construction activity and how they were performing the development of this property. They were on notice of that. I think that's all. I would just repeat and reaffirm this family, the Copeland family, they're wonderful people. I know Dr. Bill Copeland, who is a professor, is listening online, and his wife Ashley is for their son. And I'd ask that the court affirm the ruling of the Court of Appeals, remand this case to Orange County for trial. Thank you.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.
Thank you.
Thank you, counsel.
Thank you.
Thank you.
Thank you,
Good
everyone.
to see you.
Good to see you, Steve. Great
You have-
argument.